Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of approx 700 words at the speed of 140 words per minute. So get ready for the dictation. 3, 2, 1 and go. It is not disputed that the accused appellant Ram Dulare is a handicapped person who has filed his disability certificate issued by Medical Board of Chief Medical Officer MAU certifying 60% disability in his right leg, and it has been admitted by PW2 and PW3 that the accused appellant is a handicapped person disabled with one leg and cannot walk properly because of problem with one leg. It is not the case of the prosecution that the accused appellant was having love affair with the victim, the minor girl, and enticed her away on account of the love affair. It is also pertinent to mention that since the accused appellant is a handicapped person, until and otherwise proved, no girl is supposed to fall in love with such a disabled person, and so even in case of any one-side liking of victim by the accused appellant, there can be no reason for the victim to go with the accused appellant at her own. There is no whisper of any force having been used by the accused appellant or the other accused persons in forcibly sitting the victim in jeep with the accused appellant. It has also been contended by the accused appellant that the victim was major and was living with her parents in Jaunpur, and the police have not made any efforts to trace out the victim at Jaunpur or anywhere else where the appellant allegedly taken her away. It is pertinent to mention that the first informant is a law graduate, and it is expected from him as a prudent man to inform the police immediately after the incident so that there could have been better possibility of tracing out the victim. The prosecution has also not made any efforts of tracing the victim by taking the accused appellant on police remand. The prosecution has failed to explain the inordinate delay of around 4 days in lodging FIR. It has also been contended that as per entries in the family register, the victim was major at the time of incident. The possibility of eloping of victim in the darkness of night without knowledge of anybody may not be ruled out. Admittedly, the first informant PW3 is highly educated person and postgraduate, as has been admitted by him in his cross-examination at page 8 of his cross-examination that he is MA LLB. He has stated that he lives at home and does agricultural work, and since the matter was related to his prestige, he was very much nervous, and so instead of writing the written report himself, got it written by Harish Yadav on his dictation, and in dictating there was no problem. It is pertinent to mention that the father of the victim had come the very next day, but no reason has been assigned as to why the FIR was not lodged by the father himself. PW1 and PW2 are only chance witnesses and have also stated to have inquired into with co-accused as to where the victim and the accused appellant have gone, but even when no reply was given by them, they did not inform the first informant or father of the victim. Similarly, on alleged asking by PW1 and PW2 from Ram Manohar and others, not giving any threat by them is quite unnatural, while on mere inquiry by the first informant, they allegedly threatened him. The first informant has not assigned any reason when neither he was eyewitness of the occurrence nor got any information from alleged eyewitnesses, then why on what ground he approached the family members of the accused appellant, that is co-accused persons, for inquiring about the victim. It is settled principle of law that the evidence of interested or related witnesses should be considered with caution, and until and unless it is found to be trustworthy, the conviction of accused on the basis of evidence of related or interested witness is not justified. In view of the discussions made above and considering the unnatural conduct of PW1 and PW2, I am of the considered view that they are not proved to be eyewitnesses of the incident of enticing away victim by the accused appellant in presence of co-accused persons or otherwise, and their testimony is neither reliable nor trustworthy. Stop.